Good morning. If you could please take your seats, we're ready to begin. The Subcommittee on Elections of the Committee on House Administration will come to order. On behalf of our chair, Zoe Lofgren, I'd like to thank the members of the subcommittee, Pete Aguilar, and my colleagues from the House who are here with us today, as well as our witnesses and all those in the audience for being here this morning. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks, and that written statements be made a part of the record. Thank you. Hearing no objection, so ordered. My name is Marcia Fudge, and I am the Subcommittee Chair on Elections. I want to thank my colleagues, our witnesses, and the people of Georgia for joining us here today. I also want to thank my distinguished colleague who is going to be here shortly, John Lewis, a living hero of the Civil Rights Movement, for welcoming us so warmly to his district as we continue this important work. I cannot think of a better place to continue our discussion on why all sections of the Voting Rights Act are still essential to ensuring all Americans can exercise their constitutional right to vote than in this state, the state of Georgia. After the Supreme Court's decision in Shelby County v. Holder, Georgia moved quickly and aggressively to roll back voting rights. Between 2012 and 2016, 750,000 more names were purged from the voter rolls than from 2008 to 2012. Of the 159 counties in the state, 156 reported increased removal rates, including in the state's most populous counties. Just last year, the state attempted to close 7 out of 9 polling places in majority black Randolph County. Georgia has closed more than 200 polling places statewide since 2012. We have with us today Georgians who are right in the middle of the fight for justice. Stacey Abrams, whose activism and campaigns have brought national attention to Georgia. Stacey Hopkins, who will be joining us on the next panel, an active voter who was illegally purged from the rolls. Sean Young, a litigator from the ACLU, who has represented disenfranchised voters all over the state. And Cliff Albright, co-founder of Black Votes Matter, whose group speaks up for the vulnerable and marginalized black communities. And lastly, Gilda Daniels of the Advancement Project, who fights for us all over the country, including Georgia. I look forward to your testimony, and I thank you on behalf of the people of the United States. Ms. Abrams, welcome. The floor is yours.
Thank you, Chairman Fudge, committee members. Chairman Fudge, committee members, I appreciate the opportunity to address this hearing today. I hold the right to vote to be the most fundamental privilege of a citizen. My parents, who were active in the civil rights movement, instilled in their 6 children a reverence for the franchise and an obligation to protect it. I do not view this responsibility as partisan. When credible, nonpartisan issues on voting arise, I have worked with all comers to identify the most effective means to guarantee access. Likewise, when legislators and others sought to unfairly restrict the right to vote, I worked hard to defeat it. In addition to standing as a candidate for governor in 2018, I served in the role of minority leader for 7 years, where I had a broad view of the challenges facing voters across the state. Moreover, as the founder of the New Georgia Project, one of the state's largest third-party voter registration organizations, I have firsthand experience with the obstacles embedded in the registration process as managed by the prior Secretary of State, Brian Kemp. Moreover, as a longtime advocate for voting rights, I am deeply concerned about the impact on our democracy if action is not taken immediately to support access to voting rights for all eligible citizens. On November 6, 2018, Georgia experienced unprecedented turnout in its midterm election. Communities long isolated from the electoral process cast their ballots, including increases in voting across racial and ethnic groups and age groups. Most fairly, this surge should be attributed to those grassroots organizations that work hard not only during election cycles, but year-round to build civic engagement and to broaden participation in the polity of Georgia. While this dramatic increase in voter participation should be celebrated, the rise in turnout cannot be allowed to mask a more troubling trend. Voters, many of whom were first-time voters, experienced numerous issues with being located on the voting rolls, receiving and returning absentee ballots, and were given a disturbing number of provisional ballots rather than being allowed to vote unhindered. In some areas, the elections officials refused to provide provisional ballots, citing a shortage of paper. In counties, polling locations ran out of provisional ballots and backup paper ballots. Frustrated voters received inaccurate information regarding their rights, and thousands of voters were forced to vote using provisional ballots due to long lines. An untold number simply gave up, unable to bear the financial cost of waiting in line because Georgia does not guarantee paid time off to vote. Across the state, voters faced obstacles that shook their confidence in the electoral process, leading to more than 50,000 calls to a local voter protection hotline in the 10-day period immediately following the election. From issues with registration to ballot access to the counting of votes, Georgians faced a systemic breakdown in its electoral process. In response, on November 16th, while I acknowledged the outcome of the election, I also called upon my fellow Georgians to join me in pursuing a fair and equitable system that operated effectively, efficiently, and equally through the entity Fair Fight Action. I did so in full awareness of a decade of actions that had undermined the election system, often misappropriating existing laws or operating in ways that faced legal challenge. While several of these federal lawsuits worked, the Secretary of State and others pushed through local laws to restore obstacles to voting. Yet we must recognize that Georgia's experience, while singular, is not unique. In 2013, with the effective neutering of the 1965 Voting Rights Act, states and localities raced to restore or manufacture new blocks on voting. Unfortunately, Georgia has been a leader in this endeavor. However, this attack on voting rights is not new. Though the speed of constraints quickened in the years after the Shelby decision, for Georgians, voter ID laws came first, followed by an increase in closed or consolidated precincts, assault on third-party registrations, database challenges that spoiled legitimate registrations, vulnerable or inadequate equipment, and lax oversight of county application of state laws, leading to disparate treatment based on county lines. Incompetence and malfeasance operate in tandem, and the sheer complexity of the state's voting apparatus smooths voter suppression into a nearly seamless system that targets voter registration, ballot access, and ballot counting. Madam Chair, I know that my time is about to expire, but I would like to extend my remarks if possible. Thank you. Over and over again, these hurdles have had their desired effect. In Georgia, the then Secretary of State purged more than 1 million voters, oversaw local closure of more than 200 precincts, held the registrations of 53,000 using the flawed process of exact match, and presided over what some report as the longest voting lines for Black voters in the nation. Naturalized citizens had to sue for their newly secured rights, and organizations continue to fight for ballots in multiple languages. Unfortunately, Georgia also neglected its elections infrastructure, resulting in vulnerable, sometimes inoperable machines that were inadequately distributed to communities. Multiple times, the lines drawn for districts have been misapplied or miscommunicated, forcing do-over elections or disqualifying otherwise eligible candidates. In isolation, each example is troubling, as it represents a voter who could not fully participate in the body politic. Combined, they represent the disenfranchisement of Georgia voters in general and targeted communities of color or low-income neighborhoods in particular. Our goal is to reform Georgia's election management system by ensuring that voters who are duly eligible to register are not unfairly blocked or unfairly thrown off the rolls. Georgia must maintain an accurate, functioning voter registration list. In Georgia and around the country, the closure or consolidation of precincts unfairly punishes those who have challenges with transportation or who have other issues, including physical disability. Voters should be able to fully participate in lawful processes, such as absentee ballots. However, a number of voters reported failure to receive duly applied for ballots. Counting duly cast votes is also an uncertainty in Georgia. A disturbing number of absentee ballots were rejected in 2018, and previously the former Secretary of State used the lawful right to absentee voting to target and prosecute citizens. In addition, Georgia has a provisional ballot system that is inconsistently applied. Administrative issues plague the process, including allowing different standards for the administration of elections in each of Georgia's 159 counties. In addition, Georgia should be compelled to replace insecure and unreliable voting machines with paper ballots, and to do so with a procurement process that does not unduly enrich any allies of the leaders of the state. We would also benefit from a true statewide election supervisor who applies uniform standards and adequate resources for training and election administration. Georgia is the cradle of the civil rights movement, and we are capable of conducting free and fair elections with record turnout. Yet on election day, voters faced extremely long lines, registered voters missing from the rolls, insecure, inadequate, and malfunctioning voting machines, insufficient provisional ballots, and election staff who were ill-equipped to meet voters' needs. Yet these are all issues that can be solved by people of goodwill who recognize that no electoral process is perfect, but that perfection should be the goal. I am fighting for fair elections with the deepest recognition that improving our system will not change the outcome of November 6th, 2018. However, as a citizen of Georgia and as an American who believes in our system of representative democracy, I am obliged to do all in my power to advocate for an end to voter suppression in all its forms and in all its spaces. On behalf of millions of Georgians, I express our gratitude to this committee for your willingness to investigate and understand the threats embedded in our state's electoral apparatus. Together, we can press forward for an electoral system that truly represents and listens to its people. Thank you.
Thank you very, very much. First off, thank you for your time. I know it was a little difficult with some of the shifts we were making, so we appreciate it. But let me just say to you that on behalf of us all, and especially the work that is going to be done by Representative Sewell and Representative Lewis with their bill and the work we're doing, we are here because of what happened in 2016. Yeah. We are here because we are going to make it right at some point. We're going to make it right. You know, as they say at home, we're going to fix it.
Thank you.
I promise you we will.
You.
I'm going to, if you just have a few minutes, I will allow just a quick question from each one of our members. Do you have time for
Absolutely.
that? We would start with my colleague on the committee, Representative Pete Aguilar of California.
Thank you, Ms. Abrams. So we appreciate your testimony. I wanted to ask you about the chilling effect. I know you have so much history and knowledge on voter registration efforts. Can you talk about the chilling effect for ongoing voter registration efforts that exact matches and all of these signature issues play in ongoing effects that's going to have on voter registration efforts?
Absolutely. Thank you, Congressman, for the question. As the founder of the New Georgia Project, I'm proud of the work we've done to register more than 200,000 new Georgians during my tenure as the leader of the organization, and since that time, I believe another 100,000 plus have been added to the rolls. However, what we experienced through the exact match system necessitated that our organization keep paper records of all applications. This is despite the fact that Georgia offers online registration. The challenge with online registration is that there is no adequate way to monitor and maintain that voters who apply are actually processed. Therefore, we maintain paper copies, which the Secretary of State, then Secretary of State Kemp, disparaged, but which is the only reason we were able to, in 2016, file suit to discover his illegal, what we would say is unlawful use of the exact match system. It unfairly captures people of color and women. It has a disproportionate effect on people of color, and it has a chilling effect because these are communities that are least likely to register but for third-party registrations. We have to add to that the fact that under Secretary of State Kemp, not one but two organizations of color were raided by his office, challenged for their very act of registering these new voters. And so what I would say is, yes, there is a chilling effect because of exact match, but also because of the hostility demonstrated by the then Secretary of State towards the act of registration. Unless you did it his way and the right people were registered, he displayed a disparaging and I think deeply disturbing response to registration. He would argue that he increased registrations, and I would certainly point out that registrations increased despite his behavior, not because of it.
Thank you.
Mr. Bishop of Georgia.
Thank you very much, Ms. Abrams. You have had a long history of fighting and working for the expansion of voter participation and registration. And of course, the work that you did with the New Georgia Project was extraordinary. Early on, you experienced some pushback from the then Secretary of State, and a number of those 200,000 were disqualified. You also, I believe, discovered that Georgia's system of allowing the Motor Vehicle Bureau, when a person applies for driver's license, to have automatically their information sent for voter registration. I believe during the course of that, you discovered that that information was not being transferred to the Secretary of State's office, and if it was not being recorded. I think you also discovered that there was some cases of prosecution of individuals who availed themselves of the lawful absentee voter process in Brooks County, for example, which resulted in a SWAT team descending on the county after the election, where school board members, a majority of the school board was elected by minorities, and held the school board, and subsequently, shortly after they took office, they were indicted. And of course, there was a 2-year waiting period between the time of the indictment and the time they finally went to trial and were acquitted, which had the effect of a 2-year chilling effect. Could you discuss that and perhaps even some of the irregularities in Early County,
Sure.
The similar circumstances?
I think what's important to articulate in this process is that these are not isolated incidents, that the behavior that was evidenced over the course of a decade by the then Secretary of State demonstrated a deep disregard for the voting rights of all Georgia citizens. What you described is often referred to colloquially as the Quitman 10. 10 people who, during the process of trying to stand up for their children in their community, successfully advocated for voter turnout levels that allowed African Americans to sit on the school board at numbers previously unseen. And in response, they were arrested, they were harassed, many lost their jobs, several were never able to reclaim their good names. One person, I believe, was permanently disenfranchised, despite the fact that not a single case was found, not a single person was found to be guilty during the process of the litigation. Similarly, in Hancock County, when too many African Americans showed up to vote in 2014, the current chair of the Judiciary Committee in the House of Representatives, Barry Fleming, who is also the purveyor of legislation that will further, I think, extend disenfranchisement, he authorized the following home of African American voters to investigate whether they were lawful voters in Hancock County. And this investigation was conducted, and sometimes by the sheriffs. So it's not simply a chilling effect, it's an intimidation effect. And what we have to understand is these are Georgians. These are American citizens whose lawful right to cast a ballot has been constrained by his behavior. I know that those others who will be testifying can provide deeper information, but I will say this. We have to understand that voter suppression is not simply a momentary act. It is a system of disconnecting our citizens from the policies that govern their lives. If we want communities to stand up for more, they have to be allowed to speak up when they stand up.
Can I just get you to follow up and talk about the inability to monitor the actual counting of votes, because the system does not have a paper trail?
I will say that at 3 p.m. today, The state legislature will be considering legislation that's been put forward that would trade our currently inoperable, vulnerable, and hackable system for a further hackable system at a higher price tag that will then actually benefit colleagues of the current governor. But here's the point. We do not have an auditable trail in Georgia. We cannot audit our elections. We cannot prove that the votes cast or the votes counted. And when you have no faith in the system, you have no reason to participate in the system. And that chilling effect should be worrisome to us all.
Thank you very much. Mr. Johnson of Georgia.
Thank you, Madam Chair, and thank the people who are here on this very important issue. And thank you, Senator Abrams, for, I'm sorry, Governor Abrams, gosh, I don't know, whatever the decision might be. I know that there's going to be a prefix in front of that name, but I very much appreciate the work that you are doing with Fair Fight. I don't know if you've spoken about that yet this morning, but if you could give us a few words about that. But I also want you to educate the panel on the undercount, the drastic undercount that took place in the lieutenant governor's race, and tell us what your organization is doing in that regard.
Certainly. Fair Fight is a nonpartisan voting rights advocacy organization. I'm proud to serve as our founder and chair. The CEO is Lauren Growargo. What we attempt to do in all parts of the state is to lift up the issue of fair voting, making certain that there is equitable, efficient, and truly equal access to the right to vote in the state of Georgia. But it's also about connecting the right to vote to the very policies that the right to vote undergirds. We know that, for example, in the 2018 election, in the lieutenant's governor election, there was statistically significant drop-off, an undercount that almost specifically affected African Americans. And it was a statistically significant drop-off because it did not occur in any other race other than the lieutenant's governor's race. Now, the reason for that could be numerous. The challenge is that, to Congressman Bishop's point, there is no way to find out what the problem was because Georgia has machines that do not provide an audit trail. Unfortunately, the current machines under suggestion have similar flaws. We have to have a system that allows for paper ballots and for hand counting of these elections because machines are insufficient to guarantee access to the right to vote in the state of Georgia.
Thank you very much. Mr. Richmond of Louisiana.
Thank you, Madam Chairwoman. It's always good to be back in my second home. I went to Morehouse, and it's great to always talk to my Spelman sister. In your experience, let me just ask a very pointed question, because we're here without the protections of the Voting Rights Act, more particularly Section 4B and 5. So my first question would be, when that was designed and enacted, the formula was all about jurisdictions that had tests and devices to keep people from voting. So fast forward to today, we have to talk about the new conditions and where we are now. So my question would be, one, in your experience, does Section 2 provide an adequate remedy when you see a problem being acted before the consequences are too dire? And the follow-up of that would be, instead of poll test and other things, what are, if you could just, in your testimony you say, but if you could just specifically and quickly articulate what has now become the new test and barriers, it would be very helpful.
Certainly. And I certainly know there are additional lawyers who will speak to this more specifically, but here's what I would say. Section 2 essentially says that a bad action can be used as a predicate to argue that a new bad action cannot be taken. The challenge there is that you have to have someone disenfranchised before you can fight to make certain that someone else isn't disenfranchised. But that means that someone lost their right to vote. That means that communities were disallowed from actually having a voice in their community. The beauty of Section 5 said that before you commit harm, you had to be held to a higher standard. Section 2 says once harm has been committed, you have the ability to argue that it shouldn't be repeated. And therefore, it is an insufficient standard for a nation that is grounded in the notion of democracy, and representative democracy is the way to push forward our thoughts and ideas as citizens. The poll tax issue is this. In the state of Georgia, for example, you do not receive paid time off to vote. You cannot be fired from your job for going to vote, but you do not receive paid time off. On its own, that seems sufficient, potentially. But Georgia has a disproportionately high number of service workers, meaning those who are very much paycheck to paycheck workers. In the state of Georgia, if you're African American, you are more likely to face long lines, sometimes to the level of 4 hours. That's half a day's pay. And for families living paycheck to paycheck, losing an entire day or half a day's pay, and that doesn't take into account the time it takes you to get to your polling place and the time to get back to your job, that is an economic cost that is quantifiable and therefore I believe should be allocated as a poll tax, which we have said under the 15th Amendment should be unlawful in the United States of America.
Thank you. Representative Sewell of Alabama.
First, a point of personal privilege. I just want to say to Leader Abrams that you did all of us proud in your campaign and your run for governor, and I wish you much success in all of the future endeavors. All I can say is black girl magic. As a daughter of Selma, I have to say that when Congress enacted the Voting Rights Act of 1965, it had a dramatic effect on allowing African Americans and people of color, those who were the minorities in their communities, to have access to the ballot box and thus a voice. In fact, the number of folks that registered increased exponentially in places like Marion, Alabama, where Perry County, where only 6% of the African Americans were registered. It went to something like 80%. In your position as leader, minority leader in the Georgia state legislature, after the Shelby versus Holder decision, did you see a dramatic increase in activity by the state legislature to add further restrictions on voting, such that it made it harder for folks to vote? The Supreme Court said in its Shelby decision that our formula was outdated, and that really there was no cause for us to discriminate against certain states for prior actions. And so I'd love to know your thoughts as a legislator, a state legislator, whether or not the decision was had a chilling effect, or did it allow a lot of state laws to be imposed that were discriminatory. That would go to the heart of whether or not we need to, as a Congress, put back in place a formula and put the teeth back into Section 4.
So here's how I would frame it. In the state of Georgia, the Shelby decision did have a very insidious effect. But what we need to remember is that it not only governed the actions of state legislatures, it governed the actions of appointed folks or other elected officials, including secretaries of state and county officials. And what is so pervasive in the state of Georgia with regards to diminishing the right to vote was that it was the Secretary of State who had almost unilateral authority to, I would say, manipulate existing state law, but then impose his own policies that were not subject to public review or to judicial review or the judiciary review of the Department of Justice. And therefore, without passing a single new law, he took existing laws and used those laws as weapons against their own people. During my tenure as leader, we actually had a very effective relationship with the majority party, and I was able to forestall, working in cooperation with members of both my party and the other party, to forestall more deleterious legislation, unlike legislation that passed in North Carolina and Texas, and in your home state of Alabama. We did see in 2017 probably the most perverse expansion of this power, which is that a federal judge said that exact match had a disproportionate effect on people of color and women, and the Secretary of State agreed not to use the system for approximately a couple of months. He then came to the legislature and said, please put into law that which I consented not to use. And there was no judicial review. And so I think it's important for us to restore Section 5, because We have a complicated system in our country. Representative democracy doesn't simply happen at the congressional or state legislative level. It happens at every level of elected and appointed government.
Does that
and
rise to the
every
level
person-
of needing federal oversight?
Absolutely, because that federal oversight, and this goes to Congressman Richmond's question, that oversight allows us to cure problems before harm is caused. Under the current system, harm has to exist, and that harm has deeply deleterious and long-standing and deep-reaching effects. Going to Congressman Bishop's question, the effect on the Quitman 10 did not simply harm those folks. It actually diminished participation in the elections. It limited and had a chilling effect on voters, and it hurt children who deserve to have voices at the table looking out for their best interests, and that's fundamentally what democracy is about, speaking for the people.
Thank you, Madam Chair. And
Thank you. And Ms. Abrams, we want to thank you, not just for being here today, but for the work you have done for many years, for your dedication and your commitment to the people of Georgia and this nation. We will be back in touch with you. We are going to go across the country. We have many more of these hearings to have in other states. We're going to ensure by the time we get to 2020, we will not be dealing with the same issues that we are dealing with today. And I just want to, there's a young man sitting in the audience that I met this morning. He came and introduced himself to me. His name is Niles. He's in the 11th grade. I don't even know why he's not in school, but he...
Niles is a very active
But
young
you
man.
know what? You've learned a lot already this morning, Niles. Keep up what you're doing. Keep being involved. He starts to talk to me about the ACLU case in Ohio. I'm looking at him like, where did you come from? But it is people like you, young people like you, that are the next Stacey Abrams. So keep doing what you're doing, young man. And again, I thank you so much. It's time for our next panel. Thank you very much, Ms. Abrams.
Thank you, Madam Chair. Thank you.
All right. Next panel. You're going to put your names up. We are pleased to begin our second panel. Again, I'd like to introduce our witnesses. They are Stacey Hopkins, an active voter who was illegally purged from the rolls; Sean Young, a litigator from the ACLU who has represented disenfranchised voters all over the state of Georgia; Cliff Albright, co-founder of Black Voters Matter, whose group speaks for the vulnerable and marginalized Black communities; and Gilda Daniels of the Advancement Project. Welcome all. Each of you will have 5 minutes to give your testimony. We will hear all the testimony, and then we will open it to the panel for questions. You will see the light system. Green means go, yellow means prepare to close, red means close as quickly as you can. Thank you very much. We would begin today with Ms. Hopkins. You don't want to start? I'll start down here. All right, all right. Let us start with Ms. Daniels.
Good morning. Thank you for the opportunity to provide remarks on voting rights and election administration in Georgia. My name is Gilda Daniels. I am the litigation director for the Advancement Project's national office. Advancement Project is a national racial justice organization that partners with grassroots organizations on the ground to inspire, empower, and develop community-based solutions. The premise for this approach is based on the strategies and courage that produced the landmark civil rights victories of earlier eras that utilized the tools of social activism to create meaningful change. Here in Georgia, Advancement Project is proud to partner with the New Georgia Project to advance voting rights. In addition to my work at the Advancement Project, I'm a tenured professor at the University of Baltimore School of Law. And also, most importantly, I am a former deputy chief in the United States Department of Justice Civil Rights Division voting section, during the Clinton and Bush administrations. I have been a voting rights attorney for more than 2 decades. I'm a member of the State Bar of Georgia and have been involved in monitoring voting issues in Georgia, including during the 2018 general elections. Accordingly, I have watched the cycles of voting rights ebb and flow from the expansion of voter registration opportunities under the National Voter Registration Act to the proliferation of disenfranchising tools such as voter ID and proof of citizenship laws that are prevalent today. Through these twists and turns, the primary tool for ensuring the free and non-discriminatory access to the right to vote has been the Voting Rights Act of 1965. The Voting Rights Act had two primary provisions: Section 2, which is essentially the litigation arm of the Voting Rights Act, and Section 5, which provided federal oversight in its covered jurisdictions. And those jurisdictions were determined by a formula within the Voting Rights Act that was found unconstitutional in the 2013 case, Shelby County versus Holder. That is where the United States Supreme Court found the coverage formula contained in Section 4 of the Act outdated and therefore unconstitutional. And this was significant because Section 4 determined jurisdictions that were required to make submissions to the federal government under Section 5 of the Act, meaning any voting change had to be submitted to either the Attorney General for the United States or the United States District Court for the District of Columbia to ensure that it did not place minority voters in a worse position, that it was not retrogressive, that it did not go back. In jurisdictions like the state of Georgia and many states in the South, Georgia, Alabama, Louisiana, Texas, parts of Florida, parts of North Carolina, Virginia, were all covered jurisdictions. So removing the requirement that these jurisdictions submit these voting changes certainly eliminated a key weapon in the voting rights arsenal. Section 5 served as a safeguard for discriminatory voting changes. It was an important prophylactic that prevented jurisdictions from implementing laws that harmed minority voters. It provided important oversight for voting changes and practices. It prevented jurisdictions from implementing laws without providing notice to minority communities. Without Section 5, jurisdictions are free to pass and put laws into place without considering the impact on its citizens. These laws go into practice, and civil rights groups are burdened with the responsibility of learning of these changes that were once routinely submitted to the federal government. More importantly, these legal changes happen after the changes have occurred, not before, as under Section 5. And after the Shelby decision, we saw new restrictions on voting have been implemented in southern states that were previously covered by the Voting Rights Act's pre-clearance provisions. Georgia, in particular, instituted a number of retrogressive and arguably discriminatory practices, such as voter identification and proof of citizenship requirements, cuts to early voting, closed hundreds of polling places in communities of color, and undertook massive voter purges. Leading into the 2018 general elections, as Ms. Abrams described, Georgia placed more than 50,000 voter registrations on hold, provided inoperable voting machines and untrained poll workers for its elections. It also designated eligible voters as non-citizens and then required them to prove otherwise in a precarious and opaque system. Prior to the dismantling of the Voting Rights Act and the Shelby decision, Section 5 would have required Georgia and its sub-jurisdictions to seek preclearance prior to implementing these changes. If Georgia had been subject to Section 5, many, if not all, of these practices would have never been introduced. It would have had the burden of demonstrating that the proposed practice did not impede the right to vote. The years of litigation and frustration would have been avoided had the protections of the Voting Rights Act remained in place. Without Section 5, civil rights groups and individuals face the costly task of litigating voting practices after they have adversely affected communities of color. I saw some of these problems manifest firsthand while monitoring voting in Georgia during the November 2018 midterm elections. I see that my time has expired. Thank you very much. Thank you. Quickly, I again want to thank the committee for having this hearing, and it is imperative that we develop a federal solution that eliminates discriminatory barriers to the ballot box. Ideally, Congress should restore federal oversight over voting changes, and I would also add that we also need an affirmative and explicit right to vote in the United States Constitution. I want to thanks to Chairwoman Fudge and the Subcommittee on Elections for holding this field hearing. It is time for Congress to act, to reinstate the protections of the Voting Rights Act.
Thank you very much. Thank you. Mr. Richmond.
Madam Chair, I would ask unanimous consent to put the written testimony of all of our witnesses in the record, and that would be Mrs. Hopkins, Mr. Albright, Ms. Daniels, and Mr. Young, so that their entire comments are in the record, as well as Ms. Abrams.
Hearing no objection, so ordered. Thank you, Mr. Richmond. I now recognize Mr. Young.
Good morning. Good morning. My name is Sean Young, and I'm the legal director of the ACLU of Georgia. Today, I'm going to highlight 3 areas in which the Shelby County decision has made it more difficult for people of color to exercise their right to vote in Georgia, as well as the strenuous efforts required to beat back these measures without preclearance. And I'm speaking based on my personal knowledge as a voting rights lawyer in Georgia. I'm going to focus on 3 areas: redistricting, polling place closures, and early voting cutbacks. First, discriminatory redistricting. The ACLU of Georgia's litigation in Sumter County perfectly illustrates the damage that the Shelby decision has caused. In 2011, 67% of the Sumter County Board of Education was African American. Then the General Assembly proposed a plan that would reduce that percentage to 28%. The DOJ did not pre-clear the plan, but then the Shelby County decision was handed down, and that discriminatory plan was put into effect immediately. So the ACLU filed a voting rights lawsuit under Section 2. And last summer, after 5 years of litigation, the federal district court issued a ruling finding that the plan was discriminatory and violated the Voting Rights Act. That's 5 years of time-consuming litigation, hundreds if not thousands of attorney hours, and thousands of dollars in expert fees. That's 5 years of discriminatory elections taking place over and over again in Sumter County. And that's 5 years in which African American school children and their parents did not have their interests adequately represented in the board. And we're 2 years away from another round of redistricting, in which all of this can happen again. If the pre-clearance requirement were in place, none of this would have happened, and that plan wouldn't have seen the light of day. Second, I'm going to talk about discriminatory polling place closures. In the last 2 years, the ACLU of Georgia has had to beat back polling place closures in 3 counties: Randolph, Fulton, and Irwin. Last August, as Chairwoman Fudge mentioned, in Randolph County, the Board of Elections tried to close 7 out of 9 polling places in a county that's 60% black on the eve of the state's general elections in 2018. The ACLU of Georgia wrote a letter threatening to sue if they move forward with the plan. And then my executive director, Andrea Young, and I testified at 2 public hearings that the board held. Then our partners had to mobilize massive community opposition to show up at these hearings and express their opposition. Our media strategy ensured wall-to-wall media coverage. We quickly put together a lawsuit that could be ready to go as soon as this plan went into effect. And all of that happened in less than 2 weeks. All of that had to happen before the board finally relented and withdrew their proposal. And then we learned it was a consultant handpicked by the Secretary of State that had recommended these discriminatory polling place closures. And he bragged about having closed polling places in 10 different other counties in rural Georgia. 9 of those 10 are disproportionately black. In Fulton County, the Board of Elections voted to close polling places in neighborhoods that were over 80% African American, affecting over 14,000 voters. Within days, the ACLU of Georgia filed a lawsuit over the board's violation of the state's public notice law, which nullified that decision. But the fight wasn't over. Our partners had to quickly recruit dozens of paid neighborhood canvassers to go out in the community to draw opposition to this plan in less than a month. And it was only after those efforts that the plan was defeated. In Irwin County, the Board of Elections tried to close the only polling place that existed in the only black neighborhood in the county, contrary to the recommendations of a nonpartisan association of county commissioners. And the board alleged that it wanted to save money. Yet, their plan kept open a polling place at the edge of the county at Jefferson Davis Memorial Park, in a neighborhood that was 99% white. It was only after the ACLU of Georgia threatened litigation that they backed down. And those are only 3 counties. Georgia has 159. And as we all know, over 200 have closed since Shelby County. Playing whack-a-mole is not a sustainable strategy to fight against voting discrimination. last, and I'll wrap up quickly. Discriminatory cutbacks to early voting. I actually have some personal experience with this, leading ACLU's litigation in Ohio to fight against their discriminatory early voting cutbacks. Seems like every year since Shelby County legislators have been trying to attack early voting, especially early voting on Sundays, which everyone knows is when African American churches organize souls to the polls. In 2014, a state representative criticized his county for allowing Sunday voting, and he wasn't shy about why. He said, quote, "This location is dominated by African American shoppers, and it is near several large African American megachurches," unquote. In his view, he said he would, quote, "prefer more educated voters." As these examples illustrate, discriminatory voting changes have forced lawyers and community activists to scramble and stop every discriminatory change that pops up, and that's to the extent that we hear about them. We don't and can't stop all of them, and that's why we need a new pre-clearance provision. Thank you.
Thank you very much, Ms. Hopkins. Are you prepared?
I'm going to try to do this under 5 minutes. It's going to try not to sound like speed reading. So, Chairperson Lofgren, Chairwoman Fudge, Ranking Minority Member Rodney Davis, and members of the committee. I would like to sincerely express my thanks to this body to allow me to testify today. About my experience as a victim of voter suppression, I need to clarify I was not purged from the voting rolls. Thanks to my attorney, Sean Young, and Andrea Young, and the ACLU, we were able to push back because no one is ever coming to take something that was so hardly fought from me or anyone else in Georgia. They will never take my right to vote. It's a position I also never found myself in my wildest dreams that I would be here in 2019, fighting the same issues my ancestors have waged since arriving on these shores of this country in 1619. We were led to believe that the promise of America, of liberty and justice and freedom are extended to us all. And in 1965, we were led to believe that we had a wing contained in the passage of the Civil Rights Act of 1964. Sadly, I'm here to say that the fight in opposition to that has never ended, not in this state. And it has manifested itself in disturbing ways in Georgia. For Black people and for people of color, we are still viewed as holding second-class citizenship in this state. The state of our elections and voting rights is a dire emergency and a crisis of voter confidence. We have sent out the warning signs for years. I am asking Congress to intervene to answer this call in order to protect and defend what was so hard fought for and many of us thought won. I was born in 1963. I'm a child of the Civil Rights Movement. And as an adult, I found myself living in Atlanta, part of the mighty 5th District, represented by the Honorable John Lewis. I had always heard about his stories, about his heroic stance on that day in bloody Sunday in Selma, Alabama. And in that same year, a Supreme Court decision was argued and decided, Gray versus Sanders. And it was initiated by a citizen of the same county I now reside in, by a Mr. James Sanders, who successfully challenged the use of a statewide election system found to be form of voter suppression in violation of the 14th Amendment's guarantee of equal protection, the county unit system. This system undercut and diluted the strength of the individual voter and violated the constitutional principle of one person, one vote. In 2017, I found myself a Fulton County voter challenging the legality of my state and county for beginning the process of illegally targeting myself, 3 of my adult children, and over 380,000 voters in one action in 1 year. We were part of the 1.4 million Georgia voters that were removed since 2012 by the Georgia Secretary of State office headed by now Governor Brian Kemp. We were to be classified as inactive voters and designated to be purged off of the voting rolls using a method known as the postcard trick. And I actually brought one of those postcards in so that people can see how innocent they look. This is what it looked like. This is what I received in the mail. I can't really explain all the ranges of emotions that I felt when I saw this notice. I can only best describe it as an abbreviated version of the stages of grief, except the one thing that I would never do is accept this. It put in me a desire and motivation to stand up and fight back against what can only be called this massive and systemic voter disenfranchisement that has gone on virtually unchecked. From the days of Reconstruction and Jim Crow to the erosion of the Voting Rights Act by the Supreme Court in its Holder versus Shelby decision. The problem in my case, and there's a fundamental question that I must ask that cannot be answered. What list was I on? Because in my case, I moved intra-county from one county to another. So according to the remedies that are contained in the Voter Registration Act of 1993, there was nothing for me to do other than to update my address with the U.S. Postal Service, which I did. The second problem with me receiving one of those notices is that it said that I would be deemed an inactive voter. I could not have been deemed an inactive voter if myself and my children had just voted that same year in the elections that we were eligible in. So to this date, I was not on cross-check. I was not on any list other than the U.S. Postal Service list. And if that had been followed and in accordance with the law, I would have never received those notices. So I still ask the question, what list were we on? To date, no one on the state or county level can answer us or have even attempted to do so. What was done on the orders of Secretary of State, now Georgia Governor Brian Kemp, my county election board, headed by Director Richard Barron, by utilizing a list of selected voters to receive the mailers, but we still don't know what source. The actual notice indicated that I had moved and should have been the first clue of a violation of voting statute, but we did not hear that. Long story short, on the eve of our case being heard in court, I was contacted about a settlement, and I agreed to it because there was an election upcoming where it was important that the statuses be reinstated for these voters. However, we still saw massive and damaging acts of voter suppression and disenfranchisement, from watching poll locations being closed, by watching people not finding their names on poll books who had voted for over 50 years. We saw so many actions that went on. This is a plea to you, to Congress, to please come in. There are things that you can do to, and the first is repairing, strengthening the Voting Rights Act.
Thank you very, very much.
Madam Chair, can we also have a copy of her postcard for the record?
Yes. And we'll pick up the rest of your testimony as we get to questions.
Okay, thank you.
And you were very good. I don't know why you were so nervous. Mr. Albright.
Chairperson Fudge, all committee members, thank you for the opportunity to speak today. I am the co-founder of Black Voters Matter, along with Latasha Brown. Our mission is to build power in predominantly black communities, and we view elections as one way of doing so. During 2018, we traveled throughout 7 states seeking to mobilize black voters and supporting over 120 community-based partner groups. These 7 states were Alabama, Florida, Georgia, Mississippi, North Carolina, South Carolina, and Tennessee, with honorable mention to Texas, where we spent just a few days in Harris County. Collectively, these states form the bulk of the old Confederacy, the old failed Confederacy, a historical fact which is very much related to the topic of this hearing. And while each of these states has its own examples of voter suppression during the recent midterms, the epicenter of voter suppression was arguably right here in Georgia. By now, the committee is familiar with the headlines, and we've talked about some of them. A gubernatorial candidate refusing to step down as chief election official, instead presiding over and picking voters in his own election, purging of 1.5 million voters, holding on to 53,000 voter registrations, most of which from black voters, inadequate supply of machines, which themselves are highly problematic, thousands of provisional ballots not counted, thousands of absentee ballots either lost or simply not counted, and of course what we've talked about, the closing of polling places throughout the state. Which brings me to the events of October 15, 2018 in Jefferson County, Georgia. We began our day with the voter mobilization rally at a senior center. We shared our message of love and power with dozens of seniors who were excited to participate. In fact, the group was so excited that the rally moved into the parking lot where we added some music and had a good old-fashioned dance party as the seniors sang along with James Brown. Say it loud, I'm black and I'm proud. The group then asked if they could ride our bus, the blackest bus in America, to go early vote at the polling place just down the street. But before we could depart, the center's director received a call from the county administrator stating that the seniors could not ride the bus to go vote. In the interest of time, I will spare the committee the administrator's inadequate and racist response, but will gladly discuss during Q&A. But ours wasn't the only vehicle to be blocked from providing rides to the polls. In Cordele, Georgia, one of our partners was providing rides to the polls when he was given a parking ticket by a state trooper. I repeat, a state trooper gave him a parking ticket and then proceeded to call for backup, resulting in a total of 7 patrol cars, 5 of which were state troopers. What we've seen is a pattern of intimidation, and one of the most aggressive entities has been the Secretary of State's office itself. The office has an investigative unit which has pursued several high-profile yet frivolous cases against effective voting rights organizations. We mentioned one earlier in terms of the New Georgia Project. Moreover, these armed investigators often conduct home visits to individual voters or activists, knowing that their pointless visits can have a chilling effect on civic engagement. In fact, just a few days ago, just a few days before this hearing, one of these investigators visited the community organizer who had invited us to Jefferson County. She's actually here with us today. The intimidation doesn't stop on Election Day. On November 13th, a week after the election, in the rotunda of the Georgia Capitol building, 15 peaceful protesters were arrested simply for making the very basic demand that this state should count every vote. Oddly enough, one of those arrested was a state senator, Senator Nikema Williams, in spite of Georgia law, which forbids the arrest of legislators while the assembly is in session. Now, some may hear this story and think to themselves that was after the election. What does that have to do with voter suppression? And my answer is very simple. It has everything to do with voter suppression, because those arrests, just like the Secretary of State investigations and just like the 7 patrol cars for the ride to the polls, those arrests were meant to intimidate and silence. It was meant to send a message to those arrested as well as to those watching that if you participate in these activities, if you organize and educate voters, if you demand that your vote be counted, you too can be arrested. Fannie Lou Hamer once asked a question in a hearing not unlike this one. She asked, "Is this America?" And now, 55 years later, with the weakened Voting Rights Act, evidently the answer is yes. This is America. This is Georgia. But I'm here today to say the same thing we said all throughout 2018. Every time one of our voters were suppressed, every time one of our canvassers were harassed, and every time our bus was threatened, I'm here to say today, can't stop, won't stop. Madam Chair, again, I thank you for this opportunity. I look forward to answering questions from the committee.
I thank you all so much for your testimony. We will begin with the panel, and we will start with Representative Aguilar. You're recognized for 5 minutes.
Thank you, Madam Chair. Thank you all for the testimony. My first question, Mr. Young, we have so many issues here at play, and your testimony highlighted quite a few, and then our panel expanded on the balance, redistricting, exact match, signature match, polling place closures, voter ID, early voting changes. But one I wanted to bring your attention to was specifically about access to language assistance. What requirements exist within Gwinnett and the other 158 counties within Georgia?
So Section 203 of the Voting Rights Act says that if a jurisdiction has at least 5% or 10,000 people who are of a language minority and they have depressed literacy rates, and the census so designates them as such, that county or local jurisdiction must provide ballots and registration materials in that language. And in Georgia, only one county so far has been designated as such, and that's Gwinnett County, which is one of our fastest growing in terms of communities of color counties in the state. That's the more familiar provision of the Voting Rights Act, but there's a lesser, well, it's not lesser, there's a portion of the Voting Rights Act that's less familiar to folks, and that's Section 4E. Section 4E says that United States citizens from Puerto Rico are entitled to a Spanish language ballot. That applies even if their jurisdiction was not under that 5% rule. And about a year, actually 1 year ago to this date, I testified in Hall County, which has a rapidly growing Latino population. And I explained to the board that they were obligated under Section 4E to provide Spanish language materials to U.S. citizens from Puerto Rico. And the board refused. This is the kind of barriers that we're dealing with in terms of fighting for the rights of language minority citizens.
Just to follow up, so outside of Gwinnett County, what types of language assistance? Is it zero? Do you have to petition? What remedies are available for individuals when it comes specific to language assistance outside of Gwinnett?
Outside of Gwinnett, it is zero. And so we are trying to find every way we can to get counties to voluntarily adopt language minority assistance, for example, invoking Section 4E, which was unsuccessful in Hall County. But all the counties are also obligated under Section 2 of the Voting Rights Act to provide language assistance. And we can't, as we've all started to learn, we cannot count on the census and the Commerce Department to fairly designate counties that must fall under Section 203. And so we're trying to fight everywhere we can.
Thank you, Mr. Young. Ms. Hopkins, thank you so much for your testimony. Can you talk to the panel a little bit about just kind of the broader intimidation and voter suppression efforts and what that means in your community? So when your neighbors and friends also receive those postcards, how does that make you feel about the process, and how does that make you feel about what we need to do? And I appreciate more specifically your call to action on us to do more up here as well.
I think what I witnessed, this is just one form. It's not really one particular form. It comes in various manifestations. You've heard the testimony of the precinct closures, what we call the postcard trick. We see quite a few of what we call whack-a-mole, which on election day they will change the precincts, sending people to wrong precincts to vote. It is a constant drive to meet those barriers that are put before us. And as one who has done voter registration for years in the state, it actually, the apathy started to hit me after this. After the last election, it was heartbreaking to see what happened in November, and a lot of it comes down to those voting machines, which is a big part of this. We are now just finding out that these machines are systemically moving votes from black precincts, not just any precinct, black precincts. So if black votes don't matter, obviously they do, because someone's going through quite a bit of work to make sure that they don't. What it does is that it wears one down, as Ms. Abrams, the other Stacey, spoke about earlier. You do get apathetic, and it does work to psychologically depress the right to vote. But I think that for us in Georgia, for me in particular, and for my neighbors, it does not matter what barriers are put before us. It does not matter what obstacles we face. We will continue to rise up. We get tired. We get weary. But when you think about the blood that has been on the ground for us to have this vote, and I say this quite a bit, black people, we have only had one win in this country. That was the Civil Rights Act. And for me, it is a part of my DNA. I can no longer turn away from that fight anywhere than I can turn away from my children. I will be here, old, tired, little beaten up, but I will be here in that fight in any manifestation I can be.
Thank you for your answer.
Thank
you,
you.
Madam Chair.
Thank you. Let me just pause 1 second and introduce our colleague and friend and the icon I talked to you about earlier. John Lewis has joined us this morning. Mr. Bishop, you are recognized for 5 minutes.
Thank you very much. Let me thank all of the panelists for your very informative and riveting testimony, especially Ms. Hopkins. I appreciate that very much. Each of you has identified various items that have resulted in voter suppression. Could you help us as we prepare to repair this process, provide, with respect to each of the impediments that you have encountered, a prescription for fixing it? And Ms. Hopkins, when it gets to you, would you talk about, you in Fulton County, one of the most diverse counties in the state, about the precinct administration, the elections administration on the county level with regard to diversity and poll workers, and how and who was actually implementing these policies that affected you?
Thank you. Well, pre-clearance is the answer for all of them, because without pre-clearance, these local elections officials can just get away with doing whatever they want under the radar, knowing that no one can monitor all 159 counties. But specifically and briefly, for polling place closures, polling places need to be frozen in place, and no changes can be made unless the county has done a thorough and public study of its racially discriminatory effects of their polling place closures. And they need to do it not 2 weeks in advance of their vote, but months in advance, so that the entire public and the media can fully assess whether these closures are legitimate. For early voting cutbacks, again, those have to be frozen in place. And we would argue all counties should have the same early voting hours. They should just have the same expanded early voting hours, evening and weekends. As for the redistricting measures, again, that's very hard to catch. I know there's now a bill that would allow state legislators to have veto power over any redistricting decision that is made at the local level. But those decisions also have to be made public. The maps that are being proposed have to be public. And the algorithms that people are using to draw these maps, right now they're proprietary and trade secrets or whatnot, those have to be made public. So the public fully understands how these computer algorithms are drawing these lines, how the politicians are manipulating the algorithms to benefit their own party, and for the public to fully understand it so that people can be held accountable in the democratic process.
Congressman Bishop, we need to treat the act of voting as a fundamental right. It's easier to get a gun in Georgia than it is to register to vote. So it's important that we restore the federal oversight that was lost with Section 5. In the first challenge to the Voting Rights Act in South Carolina versus Katzenbach, Attorney General Katzenbach actually said that we needed to have this, this type of oversight to ensure that we don't have to endure piecemeal litigation, which is what we're seeing now that we no longer have Section 5. Instead of requiring jurisdictions like Georgia to submit voting changes to the federal government to determine whether or not to approve those changes, we're now seeing them just implemented and then trying to first get notice of those changes after they've been implemented, and then having organizations like the Advancement Project, ACLU, and others to challenge them under Section 2 of the Voting Rights Act. So Section 2 is not enough. It is the piecemeal litigation that Katzenbach warned us about more than 50 years ago that needs, and we need restoration. And again, finally, still we can avoid this piecemeal litigation. You asked this question, it can be answered in 2 minutes, but certainly the most important thing is to restore the federal oversight.
And just quickly, I'd say definitely restoring oversight is a start. But as was said, investment in the process, right? Investment in access to the vote, investment so that there can be more polling places, so that there can be better education, changing some aspects of expanding in a sense of, why aren't 18-year-olds automatically registered to vote? And so there's so many ways where with greater investment and an investment in election protection to take some of the burden off of the community groups that are currently doing it, but to actually invest in the Department of Justice's ability to actually provide election protection and to deal with some of the intimidation issues that aren't really fully captured by pre-clearance, right? None of the intimidation gets pre-cleared. And so there's got to be a framework to deal with that, and that requires investment in resources in order to provide on oversight on the ground, particularly in counties that are so often in isolation, where a lot of these activities take place, and then they grow like bacteria and spread throughout the rest of the state.
Thank you very, very much. Mr. Lewis.
Good morning.
Good morning.
You're a good-looking group. Let me just take a moment to thank each and every one of my colleagues for being here, and thank you for being here. You're in the heart of my congressional district. Welcome. I've said on many occasions that the vote is the most powerful, nonviolent instrument or tool that we have in a democratic society. And we should make it easy and simple for everyone to be able to cast that vote. Some of you know many years ago was a young guy from Georgia by the name of Jose Williams. And this young woman, Congresswoman Terry Sewell, that in her district, her hometown, it was almost impossible for people of color to register to vote. Only 2.1% of blacks of voting age were registered to vote in 1965. There was one county in Alabama, Lowndes County, between Selma and Montgomery. The county was more than 80% African American. There was not a single registered African American voter in the county. We may not be having that problem today, but there are forces in our region trying to take us back to another time and another period. And you're bearing witness that we must not go back. We must go forward and open up the political process and let everybody come in. I think President Carter said on one occasion, being able to register to vote should be as simple as getting a glass of water. So let's make it happen. Yes. Let's make it happen. And Madam Chair, thank you for your leadership and for your vision. And I want to thank all of my colleagues again. We have a fight on our hand, and we must win it. We cannot afford to lose it. Thank you very much.
Thank you very, very much. Mr. Johnson of Georgia.
Thank you, Madam Chair. And I want to thank the witnesses for their appearance today and for their work protecting the rights of Americans to vote. I have a unanimous consent request that the postcard, that a copy of the postcard or the postcard be included in the record of this proceeding.
Yes, it's been a request for a unanimous consent that your postcard be entered into the record. I'm going to make it with you since I'm on the committee of jurisdiction. Hearing no opposition, so ordered.
Thank you, Madam Chair. I would note that 160,000 Georgians approximately over the last 4 years received such requests to update their addresses when they had simply moved from one location to another in the same polling location, same polling district. And ACLU filed a lawsuit that would compel the Secretary of State to follow the law and update their voter registration files automatically. So I want to thank Mr. Young, Attorney Young, for the work of the ACLU in bringing about that settlement. What I'd like to find out is whether or not there has been compiled a laundry list of each and every effort undertaken by the Secretary of State in his at least 4-year crusade and campaign to win the governorship with respect to making it more difficult for people, mostly African Americans and other minorities, to vote. Is there such a laundry list that has been compiled? And if so, would you tell us each and every bullet point that reflects what took place? Yeah, I want it for the record, though.
I can't produce that laundry list on command right now, but I can tell you that over a dozen lawsuits were filed last November, including one brought by the ACLU, challenging various actions by the Secretary of State and state legislators that have passed discriminatory voting measures. I know that Leader Abrams mentioned quite a few. There were absentee ballots that were rejected because signatures didn't match, which was a violation of procedural due process, as the court found. There was exact match that disproportionately hurt people of color. There were absentee ballots illegally thrown out because they didn't have the right birth date, or the birth date blank was not filled out. It's a confusing absentee ballot form. And we had a lot of last-minute litigation challenging polling places suddenly closing, or absentee ballots not even being processed. There were thousands of absentee ballots that were just sitting there because we didn't have enough election staff or oversight of the Secretary of State's office to make sure that those applications and ballots were processed within 24 hours. I personally know someone who was disenfranchised because his absentee ballot arrived too late in the mail, even though he applied for one a week in advance of Election Day. So we can help put together such a list, but those are just a few off the top of my head.
And if you would, submit it for the record for this proceeding. Yes,
Congressman
ma'am.
Johnson may also add that it's not only what former Secretary of State Kemp did, but also what each and every jurisdiction within the state of Georgia did in regards to closing polling places, moving polling places, redistricting, and other things that occurred after 2013 that would have been required, would have necessitated a federal approval before they were implemented. So a laundry list of just what Secretary Kemp, the changes that Secretary Kemp made would quail in comparison to
With
what
respect to
happened
the local and
the
state boards
Right.
of elections
Absolutely.
did.
Every voting change.
Okay.
And so when I was in the Department of Justice, of course, we received every voting change prior to its implementation. And so that would be a list of hundreds, or if not thousands, or tens of thousands of changes.
And last but not least, I would just note for the record that the 7th Congressional District race, which was won by the incumbent Republican, was lost by the Democrat by about 400 votes. And of those, and there were 1,500 or so absentee ballots that were not counted, that were discarded for various reasons. And I'll just simply state that for the record, and with that, I'll yield back.
Thank you very much, Mr. Johnson. Mr. Richmond, recognized for 5 minutes.
Thank you. Thank you, Madam Chair. Let me just quickly ask, Mr. Young, if you could, your testimony has been entered into the record, but your exhibits have not. And so if you could provide us with those exhibits, because they're actually the cases and the evidence we will need when any future voting rights renewal is passed. And that would be the redistricting fight in Sumter, Rudolph County, the polling places, Fulton County, proper public notice, Irwin County, closing voting polls, and early voting cutbacks. So if you can get those, it would be very helpful. And to the panel, when you know of specific cases, and Ms. Hopkins, let me just tell you, I am so in awe of your fortitude, your courage. You resemble not the struggle, but the strength and courage to overcome the obstacles. So when we see you, we applaud you, and we are very proud of you. But if you know anybody that didn't have the courage that you have, or who may have been beaten down too much to continue to fight, Mr. Albright, you would know, and Ms. Daniels, you would know. If you know those people, if we can get their stories, it becomes very important for us to build a record as to why what we have now doesn't work. I'm from Louisiana, and fighting after the harm is done is too late. And the other part, and Mr. Young, you may be able to elaborate on this, but we keep talking about deliberate actions that I think we can prove, but we also have to talk about willful ignorance and willful incompetence. So you know if you don't provide enough voting machines or you don't send in enough paper, if you don't know those, if you don't do those things and do your job properly, you know what the effect will be, and that is creating another barrier for minorities to vote. So as we talk about the deliberate actions, which I think we're covering very well, we still have to talk about the effects when we can't prove it's intentional, but we can prove the effects of the incompetence, whether willful or not, is creating a barrier.
That's right. I'll just say two things in response to that. Number one, intentional discrimination is not easy to catch, as we all know. Even decades ago, courts have routinely said it's hard to catch, and people are a lot more savvy now. But even where there's not that specific racist intent, there's from my experience, there's a culture of indifference, and I'll come short of saying incompetence, but indifference among many elections officials that don't realize how precious is the right to vote. And they treat it like it's another bureaucracy. So anyone in this room who has dealt with government bureaucracy knows how frustrating it can be. No offense to the legislators. And when they deal with the voting system, that's the same kind of attitude. And it is up to actually both the Secretary of State and the county commissioners to take the right to vote seriously and to provide the adequate staffing and training so that people know that they're dealing with nuclear material. I mean, this is really precious. And so I agree that there is a kind of persistent culture of indifference, even sometimes disdain, when people bring up the discriminatory impact that their actions may have.
And I guess for Ms. Daniels, anybody who wants to comment, also in the holding of Shelby, they talked about the fact that African-American turnout had gone up significantly. That's not the standard. I mean, we also have better access to transportation. We have a whole bunch of things, but the standard is not that turnout has gone up. The standard should be that turnout is what it's supposed to be. In terms of everybody who wants to vote can vote, not that we're doing better than we did in 1963. So if you want to comment on that before my time runs out. And with that answer, Madam Chair, I'll just yield back to balance my time before she starts.
Congressman Richmond, I also want to let you know I'm a daughter of the South. I'm from Winfield, Louisiana, by the way. In regards to effects and the Shelby County decision, it's certainly important to note that the Supreme Court actually acknowledged that racism still exists in active voting. However, did not consider it enough to continue the protections of the voting of Section 5 of the Voting Rights Act. The Shelby County decision has been compared to Plessy versus Ferguson, to having the same level of impact in that regard when we're talking about the effects that it has had, particularly on communities of color in denying access and certainly in making sure that there is a disparate impact. We've seen in these cases throughout the South, particularly in Texas and North Carolina, where the Advancement Project was certainly working in that case, where the court said that the state of North Carolina, that the legislators of North Carolina acted with precision, surgical precision, to essentially carve out African American communities and other communities of color to ensure that they diluted their right to vote. The impact is vast, and unfortunately the courts are not recognizing it. And we don't need to prove intentional discrimination. We need to prove that these practices and procedures discriminate certainly against people of color, and that's in using Section 2. But the bar is so high and it's so expensive. As Mr. Young mentioned, the case that he was involved in lasted 5 years. Section 2 cases last an average of 3 years and cost more than $1 million. And where, as compared to Section 5, where it was administrative, where the jurisdiction submitted the changes through the mail, and the Department of Justice then reviewed them and had 60 days to do so. So in a 60-day period, the change was either approved or denied, as compared to, and then implemented, as compared to the process that we currently have, which needs to be fixed.
Thank you very much. Thank you, Mr. Richmond. Ms. Sewell is recognized for 5 minutes.
Thank you, Madam Chair. I'd like to introduce to the record this lovely pre-prepared statement that my staff so eloquently prepared. I'd just like to submit it for the record. This is really personal for me. It's personal because so many of us know that we stand on the shoulders of folks like John Lewis. And it's not enough that we keep saying we're standing on the shoulders. We have to do something about it. And all of us have the ability and the wherewithal wherever we sit, be it a member of Congress, be it in your capacity as lawyers or as activists or community. You are a citizen of this United States and you have a right to vote. And your vote is your voice. So we have to use it. So I'm going to use my time to talk about the Supreme Court case and the challenge that was issued by the majority opinion that Justice Roberts entered. So Justice Roberts said, and I'm just going to quote him, "There is no denying that the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions." What he was saying is that we're picking on states like Alabama and Georgia and Louisiana. What is your retort as experts in this field as to why it is, because I get this all the time, my colleagues do too, why are we having to pick on certain states? If it were up to me, I say in response to my Republican colleagues, we should be pre-clearing every change in voting rights in every state and political subdivision. The reality is that we would have to have a whole division called pre-clearance in order to do that, and we would not be making that investment. We should be making that investment, but we can't. So we have to figure out ways to figure out the most egregious actors. So I would love to know from our two lawyers here what you think the response should be to Justice Roberts, and how would you help us as lawmakers having to come up with that formula articulate that?
I'll have two quick responses. Number one, as we've seen in the testimony today, racism is absolutely not over in Georgia or in the South. And anyone who has eyes and ears will tell you that. And as we've seen in the testimony today, we desperately need preclearance in the South. But the second point, I completely agree with you, Congresswoman, that we need to have preclearance in other places as well. The North and the West and these other places that haven't had that acute visible history of racial discrimination, they think they can get away with it because they are not the South. Before I came to Georgia, I litigated in early voting cutbacks in Ohio that were discriminatory, where they surgically tried to target souls to the polls and eliminate Golden Week. That was after Shelby County. And then I also litigated in Wisconsin. Wisconsin was not under preclearance, and they passed a discriminatory voter ID law. That litigation is still pending to this day. So absolutely, we need to look at other states.
Now, Ms. Daniels, the other thing that Justice Roberts said, the question is whether the Act's extraordinary measures, including its desperate treatment of the states, continue to satisfy constitutional requirements. He wants to know whether or not we have the right to supersede the 10th Amendment, which gives states their powers that are not enumerated in the Constitution. And so can you help me articulate how we in Congress can come up with a formula that actually would do that? Aside from the fact that we have a formula that would look back, not 1964, 68, 72, which he specifically said, we would look 25-year look back, 1994 going forward. But surely there are other things that we need to articulate in that formula.
Congress clearly has the authority to, under the 14th and 15th Amendments, to address these issues. It could also do it under the Elections Clause, which it did, which it used for the passage of the NVRA. And the Supreme Court certainly issued the challenge to Congress to act, in saying that Congress could change the formula so that it would not be, as it considered it, outdated and unconstitutional. And certainly we do have contemporary examples of vote discrimination that I think that it's important that Congress actually saw and used in the 2006 reauthorization.
Yes.
Which was overwhelmingly.
But there's 15,000 pages. I'm going to reclaim my time and close this out. There are 15,000 pages that were submitted back in 2006 when we overwhelmingly, Congress passed a 25-year authorization. I just want to end by saying that all of us here today have the power of our own opinions, our own voices to help articulate. Do know that we plan on filing a bill to replace Section 4, and we need you all to use Twitter and every social media to get the stories, as Congressman Richmond said, about voter suppression that's alive and well, and we need a steady drumbeat as we prove to America that we can restore the Voting Rights Act of 1965, but we must do so now. Not later, but now. Standing on the shoulders of people like John Lewis is not enough. What are we doing about paying it forward for the next generation? Thank you.
Thank you. Thank you all so much. Mr. Young, I am from Ohio. I live in Cuyahoga County, where we have about 1.5 million residents, and we have one early voting site. One. But they say it's fair because every other county only has one. Those counties that have 500 people, our county has over 1 million. And for those who would talk about states' rights, we do realize that there are some things that clearly are within the purview of the states. But I want to remind people that states' rights is why we had slavery as long as we did. So I think it's important that we recognize what states' rights really means. I want to thank all of the witnesses for your testimony. I want to thank my colleagues, our recording studio who has been live streaming this as we speak, all of those who have made this happen, all the staff that does all of this. I just come and sit down and talk. They do the work, and I want to thank them for that. My colleagues, I want to thank the Carter Center. And I want to close by just saying these things. This is the democracy upon which all democracies are measured. And if we are falling short the way we are, we have to do something. We are talking about a democracy in Venezuela, and we can't get people to vote in the United States. There was a French historian by the name of Alexis de Tocqueville, who some 200 plus years ago came to this country to determine why we are great. One of the things he said was that this country is great because we have always had the ability to repair our faults. We need to repair our faults. But he also determined that America is great because Americans are good. So it is time for good people to ensure that every American has the unfettered and unabridged right to vote in this country. It is time that people in Congress who sit with me have the courage to say to the president or whoever else is trying to be an impediment, we are going to walk past you. We're going to make sure that all the people we represent know that we represent them, not just the ones we like, not just the ones who agree with us, but all Americans. And so we're going to be here. We're going to keep this fight going. And if something like this is still happening in 2020, I'm going to be a mad sister, I promise you. This committee stands adjourned.
Section 4E case.
Oh, how good, yes.
Yeah, we need to talk about that.
Oof, I know.
So, yeah.
It's,
There aren't many. They're
no,
hard
right,
to bring.
right,
They're really
right.
hard to
It's
bring.
just a smattering here
Right,
and there. But,
right,
yeah.
right.
I apologize for interrupting. My name is Curtin Johnson. I'm a graduate student at Georgia State University, and I'm also a fellow, a new fellow for ground truth reporting, and I'm doing piece on the voting rights. So I get your information in process.